Good afternoon. My name is Shaquilla Daniel, Managing Director for Elle Daniel Associates, and this is Let's Talk Legal. Today I am joined by my mentor, former lecturer, and now blessed with the privilege of seeing my colleague, Miss Avian Joseph, Mrs. Avian Joseph, attorney at law. Good afternoon, Miss Joseph.
Hi, good evening. It's a pleasure to be here, and I look forward to sharing this very important discussion with you.
Thank you. I'm really excited about this topic. This is our first installment of Let's Talk Legal, and my intention really as Managing Director of the Elle Daniel Associates, which is a legal administrative firm, is to bring light on the legal administrative procedures for members of the public and all citizens of Trinidad and Tobago in order for them to obtain redress or assistance available to them under the laws of our land. And so it is my hope that with today's discussion we can educate our listeners on this very interesting topic. The topic is the Mental Health Act.
Yes. And especially as it comes one day. Yesterday we celebrated Mental Health Day.
Yes.
So it's an ideal opportunity to talk a little bit about the Mental Health Act and what provisions exist in the law to assist persons who may fall by the wayside in this respect.
Yes. Yesterday indeed was World Mental Health Day or Awareness Day, and for the entire month of October there has been a drive towards the focus on the awareness and the importance of mental health.
Especially in the season where we are all battling COVID. Mental health is critical.
Yes. This year's theme, if I'm not mistaken, spoke of mental health in an unfair world. Or, yes, I believe I may not have the theme verbatim, but in some way it spoke of the challenges of some who may be disadvantaged, whether it be by race, class, ethnicity, etc., but still suffer from mental illness and so would be even further marginalized have issues. And as you have addressed or highlighted, it is even more so now in the COVID-19 and this pandemic culture that we have had to deal with. Let me ask you, in your opinion, how do you think that the pandemic would have significantly affected an already volatile situation?
Well, one of the big issues with the pandemic is that you cannot socialize as you would like to.
Right.
And as all of the science is saying to us, isolation, social distance, some of the keys to be used apart from vaccination, some of the keys to be used to help us get over this. But we are all social beings. We love to interact, we love to talk with other persons, like to touch, you like to hug, like to feel. And these are the very ways in which the pandemic is spread. And so we have to avoid the things that we do naturally.
Right.
And so therefore then it will encourage depression, loss of feeling well because you can't contact your people, you can't socialize as you would like to. Anxiety, and telephone really doesn't do the job.
No. Or the virtual interactions.
And this is particularly so for persons who suffer from mental illnesses, especially elderly people who depend on social interaction and visiting family and friends. And if we have to keep away, it will worsen mental illness among people.
I understand. I definitely agree. You did touch on something that I want to expand on, and you mentioned the elderly. I found it to be quite interesting that this act especially is applicable for them, because for me, all these years, knowing of the Mental Health Act, I usually said, okay, its application is really more for those suffering with mental illnesses, the bipolar, depression, for example, schizophrenia, the list goes on. However, you brought it to my attention that the Act also applies to elderly persons who may be affected by diseases such as Alzheimer's that may be brought on due to stroke, chronic drug use, dementia, and degenerative Parkinson disease. That is rather interesting. how does the act apply to such persons and with what benefit?
All right, so the main focus of the act, as the name rightly says, is mental health.
Right.
And as you rightly pointed out, mental health affects a wide cross-section of persons. And you don't necessarily have to be 60 or 70
Right.
to suffer from a mental illness.
Correct.
You could be young and be schizophrenic, bipolar,
Right.
etc. Diabetes affect young persons as well as older persons.
Correct.
So the focus is the mental health of any one person affected
Right.
one way or the other. But what we find, particularly as people age, they tend to suffer from degenerative diseases that affect their mental health.
Right.
And a number of older persons suffer from stroke. And stroke, in many instances, affect your brain capacity.
And cognition, yes.
Right, and your cognition. So therefore then, the Mental Health Act covers anybody
Right.
and everybody who has problems with their mental capacity and cannot
Okay.
make decisions for themselves.
I got it. I get
Yes?
it. I like that because the elderly are particularly, we had a discussion previously and you would have mentioned some things that may occur locally for elderly people, right, who the act may define as patients, right? So can we get
go
into
straight?
some, yes, can we get
so
into
we can
the act
look
now?
immediately at what the act says
Right, the definitions
of a
there.
patient.
Good.
A patient is a person who is suffering from or is suspected to be suffering from mental illness or who is mentally subnormal.
Right.
So there are three elements there. One, the person is suffering.
Right.
Two, the person is suspected of suffering.
Right.
And then you're also dealing with the category of somebody who is mentally subnormal.
Interesting.
And so therefore then, in order to make a decision as to which category the person falls into, the psychiatric assessment, the medical assessment from your general practitioner, your psychiatric report tells the court exactly where you belong.
Right, okay.
It also gives, and then when we say suspected to be suffering from, because you are living with some family members,
Right.
you may be forgetful.
Right.
That is one of the early telltale signs. You may have problems generally taking care of yourself, feeding yourself, having a shower,
Right.
putting on your clothes. And so relatives will begin to realize
Something is
that
wrong.
you are having some problems with your day-to-day normal living.
Right, okay.
And so then what they do now is approach the court,
Right, with a suspicion.
right?
Okay.
But you will, and then now that takes us into looking at what you do
Right,
in order to come to court.
okay.
So it's more than a suspicion. So while you have the suspicion, before you go to court, you're going to just verify those suspicions.
With a medical practitioner, right?
You may have had, this person may have been visiting the doctor for a diabetic condition.
Right,
Right, and then they suddenly begin to, with time, it's seldom sudden, become forgetful and can't take care of themselves.
Right.
So you now have to back up that normal GP,
Right.
general practitioner observation with the observation of a psychiatrist
Right.
trained to make a determination as to the person's mental health.
I wanted to, really expand on that and make sure that we understand the requirement there, because as you rightfully said, general practitioners, they can do a general examination of the mental fitness or capacity of an individual, but you are saying for the purpose of the act, because what I am understanding from the law is that the Mental Health Act allows the High Court to make certain decisions for the welfare and benefit of the patient,
That's correct.
for things to be done on his or her behalf.
That's correct.
Right. So in order to get that to apply for the court to make such an order,
Uh-huh.
it is required that the examination of the mental capacity and fitness of the individual be examined and determined by a mental health practitioner.
Absolutely
Okay,
correct.
okay.
Because I've seen instances where people would come to court with documents from the GP.
Right, and that is not sufficient.
Because the GP will tell you, recommend, give a prescription for medication for your diabetes,
Right.
a prescription for this, a prescription for that.
Right.
And they would make certain observations. However, to concretize that, you absolutely need to have somebody trained in mental illness
Right.
to make that final assessment that guides the court.
Perfect. I love that. So we have that clear. Very important. Now that we have defined the patient and the categories under which the Act has outlined they may fall within, let us now go on to attempting to define mentally ill as described in the Act. A mentally ill person. How does the Act describe or define such an individual?
All right, so under the Mental Health Act, a mentally ill person is defined as a person who is suffering from such a disorder of the mind that he requires care, supervision, treatment, and control, or any one of them, for his own protection or welfare, or for the protection or welfare of others.
Ah, okay.
So you see, what the Act is doing is protecting the patient as well as his caregivers,
Right.
or persons with whom he or she interacts.
Yes, I get
And
it.
of course, then it will naturally, I suspect your next question will be, who can go to court?
Good,
So-
of course. Yes, naturally. So now that we have established, who we are speaking of, who may constitute as being applicable in this scenario, now I want to see, who can make the application? Is it that I can perhaps recognize that my neighbor may fall into this category
question.
and make an application to the court or to the police officers? Is it that it has to be a relative, the person has to be in my physical care? Who can apply?
All of those are important observations, questions. So, according to the Act, the first person to apply is really your next of kin.
Okay,
And of course, immediately people want to know, who is my next of kin?
right.
So if the patient is married and he lives with his wife or she lives with her husband, the wife or the husband are the first persons, is the first person to apply.
Yes, always in law. The spouse is always the first.
Spouse
next of
comes
kin.
first in
Spouse
terms of
come
nearest
first.
next of kin.
Right.
And according to the Act, it's nicely spelled out there for us. And it says, interestingly, next of kin in order of priority.
Priority. Okay.
So it tells you who can apply first.
Right.
The first person entitled to apply is the spouse of the patient.
Right.
And that could be husband or wife. The next person is the child. Then you go to the parent. Then you go to the grandparent. And then you go to the brother or sister.
The order of priority reminds me of the Succession Act.
That is absolutely correct.
Yes.
Where somebody has not left a will,
Right.
and letters of
They
administration
died
has
intestate.
to happen.
Right. And
intestate.
who can apply? It's in the same priority.
But I want you to look at the order closely. So we speak about spouse first, child, parent, grandparent, brother or sister. What is also very interesting about this is that the court has such wide discretionary powers under this Act that very recently, right in our local jurisdiction, a judge bypassed a biological daughter
Wow.
in favor of a niece.
Oh, wow.
Guess why?
I was not going to ask because that is quite interesting. What is
Because
the reason?
for two primary reasons. One, the niece has been
Okay.
the primary caregiver
Caregiver.
of the patient for a very long time.
Right.
Secondly, the niece is qualified as a nursing assistant
Ah, okay.
within that vein to administer the kind of care.
Okay.
And then the daughter, the biological daughter, really came into the patient's life late in the day.
Oh, okay.
And then, of course, the court went in to look at the circumstances of each person's living environment. The court also looks at the place where the patient is most familiar.
Right. Okay.
Because you don't want to unnecessarily uproot
yes.
as well.
Right. So the court then, though the court has discretionary power.
Wide.
Okay, with the
Wide
application,
discretionary powers.
which is very different than the Succession Act. All right. So really, if you are saying that, to me, it communicates that the spirit of this law is a social one, rather than really looking for what is in the best interest of the patient.
You are absolutely correct.
Okay.
The court is concerned about the benefit.
Right.
Benefit is a big word in this matter.
Okay.
And what is for the welfare of the
Right.
patient.
Okay.
More than what is expedient.
Okay.
Because sometimes what is expedient may not be beneficial. So the court looks at all of the circumstances. Who is the primary caregiver? The court looks at the living environment and what is familiar to the patient.
Right.
Sometimes the patient can, depending on the mental capacity of the the court will also ask the patient, what is your preference?
Okay, so they are called upon to me.
Yeah, depending on how normal,
Right.
subnormal the
Patients might be.
Yes.
Okay. So we're talking about making an application in the High Court. But
Yes.
which High Court? Because I know that family court is also considered a division of the High Courts, correct?
You are absolutely correct.
Right. So
Which
court can
application
this happen?
is founded in the Civil High Court.
Okay.
Although family is a subset of civil,
Right.
you do not go to the family division of the High Court. You go to the civil proper at the
Okay.
Hall of Justice,
Right.
or San Fernando,
Right.
and we have a High Court in Tobago as well.
Right. Okay.
So it's a direct civil High Court application.
Beautiful. That was important to know and understand. So you're not going to family court with this application.
Right.
It is the civil section of the High Court.
Yes,
Right.
correct.
The powers granted now. So we have walked through, who can apply, who can apply, where the application can be made, etc. How now? So can we move along to the procedure, the process? How can someone? So they have established, okay, this person fits the bill, right? They constitute as being a patient. I've gotten what I need to establish that they are mentally ill.
Right.
I have established that I am the next of kin in the area of priority as discussed. I know where I have to go.
Right.
How now do I make the actual application? What is required of me?
Okay. Without advertising for attorneys, the application must be made through an attorney at law.
Okay.
And this type of application is provided for under the civil procedure rules. And you must file what is called a fixed date claim form,
Right.
supported by an affidavit.
Okay.
And the affidavit is from the primary caregiver who wants to take control of the affairs of the patient.
Right.
And you would attach to your affidavit exhibits such as the medical report we spoke about, the two medical reports.
Right.
The court wants to know that what the assets of this patient is.
Okay. Interested.
Right? What the assets are of this
Right.
patient. The court also wants to know what is the income of the patient. The court also wants to know what are the expenses of the patient.
Right. So your affidavit essentially tells a story,
That is correct.
right, of the day-to-day requirements of the patient as well as their current earning ability.
That's correct.
And expenses.
That is correct.
Okay.
This patient may be in a home.
Right.
You may have a hired caregiver. And all of these things need to be accounted for. So you're correct. The court wants to know the story of the care, in a sense.
Okay, interesting. Now, in terms of the orders, right? The court, as we would have established, has a lot of power they have the power to be discretionary in terms of looking for the best interest of the patient, etc. When this person makes this application, so the affidavit is submitted, you have the exhibits, and when we talk about exhibit, let's probably break that down. An exhibit is an attachment of proof.
That's correct.
Right? That is described in the first general affidavits of the application.
Right. A good example is we spoke about the medical report.
Right.
So your affidavit may say that the patient was last seen by Dr. X on X date, and Dr. X prescribed XYZ.
Right.
So you have a
As
copy of the
outlined
prescription, and you may also have a report from the medical doctor.
Right.
So those are some of your documents that will support what you would have said in your story, in your affidavit.
Okay, good. So I'm hoping that we're able to explain that for persons to understand clearly. The affidavit is like your story, and whatever documents you reference in your story is what we would refer to as the exhibits.
Another example, this patient may have property that he's renting.
Interesting point.
Right. So you would want to let the court see the title deed.
Okay.
Of the land that is owned by the patient. The patient may have tenants.
Yes.
You would want to submit some tenant receipts of payment.
Right.
Of course, because remember we spoke about income that the patient gets.
Good.
So you would want to show some receipts from tenants.
Yes.
To support your story.
Right.
Yeah?
I get it. And it really helps me recognize that based on the responsibility, because mental illness and mental health is everyone's business, and anyone at any given time can start suffering with increasingly degenerative mental illnesses. But before that, they may have had a wide range of responsibility.
That is correct.
Right. So sometimes when we think about the patient, we think of someone who really cannot help themselves and don't have anything going on. But there may be cases when, for instance, as you said, this person would have been a landlord with several property matters having to deal with. They may have been a managing director of a company needing to make decisions, etc.
That is
so it is really important that the affidavit reflects essentially all the responsibilities that falls under the jurisdiction of the patient.
That's correct.
And does the application also include a proposed measure in terms of how it should be dealt with going forward?
You are absolutely correct, because before the court makes you what is called the receiver,
right,
or the committee, or put it in layman's language, the caregiver.
Right.
So in the act, that person is called the receiver or appointed the committee. Okay. But for the ordinary layman, that is the caregiver appointed by the court.
Okay.
The court needs to know that you are capable of doing it. The court wants to know what is the daily routine of the patient.
Right.
How is his care or her care managed at this point in time? But I want to just go back a little bit when you spoke about this person may have had responsibilities as a business person, as a landlord.
Right.
I had an instance where this gentleman had 2 strokes one day after each other.
Ooh.
And by the second day's stroke, he lost his ability to talk, he lost his ability to walk, he lost his ability to read. Right? So of course that was a very severe stroke. So his whole lifestyle changed almost literally overnight.
Yes.
And he was a welder with his own van, going to people's home, welding gates, and taking care of himself as a self-employed businessman.
Right.
But by next day, he could have done none of those things.
Wow.
So, of course, he fell under the Mental Health Act because his mental capacity was gone.
Right.
At that point.
Which makes me, as we are talking, so many questions come into mind. Usually someone may believe that the best course of action may be a power of attorney.
Right.
So what is the difference? Yes. What is the difference really between making a mental health application, an application under the Mental Health Act, as opposed to just doing a power of attorney and taking control?
Well, it looks as if you looked into my file and you saw exactly
did not.
my case. And this is exactly, I will answer in terms of a recent case. So the gentleman fell ill, couldn't walk, couldn't talk, couldn't read. And so his son hired a caregiver.
Right.
And very clandestinely, the caregiver got a power of attorney so that she can now go to the bank and take care of the financial affairs,
quote unquote, all
affairs.
right.
However, the most important point I want to make about that is that a power of attorney is between somebody who has mental capacity to a donee. So the donor gives his power. He has to be in his right frame of mind to know what he is doing and what powers he is giving to the other person on his behalf. So in that particular case, my intention is to have the court set aside that power.
Okay.
Because that power was obtained when the patient did not have the capacity to give his power.
Beautiful. I love that. And so it beautifully answers my question, and better yet, with a real life example. So the problems that this act mitigates is when the patient is in such a state mentally that they do not have the capacity to assign power.
That is correct.
And power of attorney has to be given from someone in their right state of mind or with mental capacity.
That's correct. Right state of mind,
yes,
mental capacity, sound mind.
Yes, of sound mind.
Lucid, clear.
Right.
All that will work.
I get it. And it's similar with wills. And we will do wills eventually, but it's also actually a position upon which that a will can be
thrown out.
Yes, to be said to be void,
invalidated.
Yes.
And we're not talking, airy-fairy stuff here.
Yes.
We have definite instances in our local jurisdiction where powers of attorney, when a matter has come to the court's attention under the Mental Health Act, where powers of attorney have been revoked or set aside.
Beautiful, beautiful. I love that. And so it ushers us in nicely to my next question.
Or your final question.
I can't promise, right? But close to the final question. When the applicant now, I call him the applicant for ease of understanding for me, who we had established to have been the next of kin, now the applicant making the application. When they receive that order, what are some of the powers that they now possess?
All right. The court looks at a specific situation, and then it will make orders accordingly.
Okay.
So, of course, the first and primary order the court will make is for this applicant, this next of kin who has successfully presented his or her case to the court, to take over the daily care and control.
Okay, so care and control.
Right. So that's the first priority, care and control. Depending, like we spoke about, somebody may have businesses, or they may have one business and they may have like a landlord, tenants. You are also given under the court power to take control of the real property, manage the assets of the patient.
Okay.
So the court is concerned about the person of the patient, and the court is also concerned about the property of the patient.
Okay.
Right. The court.
So one question with that, you get the power to manage the assets, but do you get ownership of the assets?
Absolutely not, which is a very important point you're making.
Right.
And this is why the court is concerned that the person who is now made the committee, the receiver, the caregiver of the patient, is not about it for selfish reasons.
Right.
There have been instances where persons take the patient's NIS money, his pension money. They buy groceries for themselves and their family and leave the patient with very little resources.
Right.
And this is why one of the things the court does as well is ask that caregiver, that receiver, to give an account subsequently as to what expenses were carried out on behalf of the patient and to account for how the patient's money was spent.
I love that. So a measure of accountability is included even after the order is granted.
As a matter of fact, sometimes the court gives you an interim order for immediate care and control and probably to immediately manage patient's property.
Right.
And for you to now account for what you've done with money in the interim, for the interim 3 months or so, until we return to the court.
Right.
And then the court
account for what happened.
May then decide to make a final decision.
Okay.
The court may, and you know, one person we forgot in all of this that tells you how the court is concerned about the welfare of the patient is the field investigator.
Okay.
So
when does he come in?
Right. So you make your application, as we said, with a fixed date claim form. You have your affidavit and you have your exhibits. Of course, we're in an era where you file electronically.
Right.
And so within 2 days or so, you will get an email from the court telling you your matter is to be heard before Justice X, Mr. Justice Y, and the date of the hearing.
Right.
The court will, if you have not served it on the office of the public trustee, the court will tell you, make sure to serve it on the office of the public trustee so that a report can be ready for the court by the time of the first hearing. So just to unpack that a little bit. So you filed your application in the court.
Right.
You must serve it on any other relative, another sister, another brother
of the patient.
That is correct.
Right.
So you have to serve it on another person who would have interest in the matter.
Right.
And you also have to serve it, like I said, on the public trustee.
Okay.
What the public trustee does is sends out a field investigator.
Right.
That person goes to the home where the patient is, interviews the manager of the home. If the patient can speak, the field investigator will interview the patient as well.
Okay.
The field investigator goes to the home of the other relatives who you may have cited in your affidavit.
Right.
And prepares a composite report for the court to tell the court what is happening with the patient. So it is independent of what you would have said.
Okay.
And the court and then an attorney from the office of the public trustee comes to court with the report to answer any questions, any follow-up questions that the judge may have with respect to the report, if the judge thinks a follow-up report is necessary as well.
Okay, that is very interesting.
So you see what that does, it gives the court an opportunity to not have just the benefit of what the caregiver says.
Right.
The field investigator is an independent person.
Right.
So the court would have had the benefit of quite a wide array
of
persons with an interest in this matter. And then on that basis, having considered all the circumstances, the court will then make a decision.
So this has indeed been really a very informative and educational discussion, and I did enjoy it thoroughly. And I am hoping that our listeners as well had as much fun as I did.
I hope so too, and got a lot of information that they may not have been aware of before.
Yes, and more importantly, for them to know what provisions there are available to them in law, and hopefully we were able to successfully outline the administrative procedure in order to access such redress, right? I think we would have really gone through the legal administrative requirements.
How to get from seeing your patient not doing well and how do you help him or her.
Exactly. Yes. So thank you so much for that. Before we conclude, I wanted to really reiterate, and even for myself, understand clearly some of the powers that the applicant, or as the Act would refer to them as the committee.
As a person, as a committee or a receiver?
Right, the committee or the receiver. Their their power is not limited to but includes the conducting of transactions in relation to the real and personal property of the patient, the acquisition, sale, and disposition of any property of the patient. So with that sale, the proceeds from the sale has to go to the estate and the benefit of the patient.
That is correct.
Not of the...
Again,
right.
not the
Everything
person, not
for
the caregiver.
Good. Permission to access
However,
NIS.
let's take a pin there. What if, remember we spoke about a patient who would have been up and well and good the day before and the next and would have been managing his business.
Right.
What if this patient had a household and he had dependent children, a dependent wife? So what you are doing now as the caregiver, the receiver, the committee on behalf of the patient, you are now ensuring that the children have university fees.
Okay.
There's food in the home.
Right.
So you're in a sense taking over the responsibilities that would have been that of the patient had he in his right mind being able to do it for himself.
I get it. And what if before the application has been made and the order granted, the applicant has been taking over those responsibilities for themselves prior to the application being made, and this has resulted in the incurrence of costs?
Right. So as happens in many instances, a patient would have money in the bank and we cannot access it because the patient is unwell and not in his right frame of mind, may be unable to hold a pen to sign a bank withdrawal slip or deposit slip or anything like that, and money's just piling up in the bank account, and the caregiver is using his or her own resources to pay for medication, pay for food, etc. for the patient. What the court does, the court is a fair place, you know. The court allows that caregiver to be reimbursed. So that you make a list, you identify all the monies that you would have put out on behalf of the patient. If the court is satisfied, is legitimate, makes sense, these are the expenses that you naturally would have incurred for the patient, the court allows for you to be reimbursed out of the funds of the patient.
Wow. I think that is definitely very fair. So reimbursement can occur.
That's correct.
Once the money would have been used for the benefit of the patient, be it debts, expenses, etc.
That's correct.
Okay, very fair. I'm seeing as well that under the Act, the person who has been appointed would be able to conduct legal proceedings in the name of the patient or on his behalf, and including but not exclusive to the execution of a will for the patient. I of course, I'm a probate baby. I describe, right? I love the probate and administration application. I find this to be rather interesting. The execution of a will for that patient. Can you expand on that for me?
No, that is really evidence of how much trust and confidence is being reposed in that receiver, that committee person, that caregiver person. You and that person would have lived or would have been acquainted with the patient for a very long time. You would have a sense of what the patient intends to do with his or her property. You would have a sense of what his or her property is in the first place.
Right.
And you are now standing in the shoes of the patient to make decisions for and on behalf of the patient as if he could have done it for himself.
Oh wow, that is a powerful power.
Yes.
It's a powerful power to have, because as we would have discussed previously, naturally the person's lack of mental capacity would have invalidated them to execute a will. But now you are saying with this order, it supersedes that, and the not the trustee, the committee.
But it's like a trustee.
The committee, it's like a trustee.
It's a trustee. A lot of trust is being imposed on you from that layman's perspective.
Wow. So you can now execute a will on behalf of the patient. This is really, really powerful and very important.
Bear in mind, it is on the order of the court.
On the order of the courts. Very important.
On
Very
the order of the
important.
court.
So I think that I really want to thank you for this information. I think that the information discussed today would only not be for the benefit of the patient, which I recognize is the intention of the act, but also to prevent allegations, family squabbles, any misuse, fraud,
Exactly.
that or mistreatment of
That's
patients
correct.
that may occur.
Yeah.
In this position. Have you seen elderly abuse and mental illness patient abuse occur
Oh,
with
yes.
the absence of this?
There, as a matter of fact, if you go to the Department of Aging, I think it's under the Ministry of Social Development.
It should be.
There is a lot of reports of elder abuse. Because the truth is, some of these older folks are almost like a child now.
Right.
And they have lost that mental capacity. And they are in the care of persons who are taking advantage of their weakness. And so this is why the court is very, very broad in checking out
Right.
and making sure before it makes a decision. And the court is also assuming that the next of kin is the best one to care.
For the
And this,
patient.
right, and this is, but then even that next of kin is under the scrutiny of the court
Okay. Okay.
to make sure. But there is a whole lot of elder abuse in our society.
This is
And the Mental Health Act is one way of helping these persons be protected from that.
right. My final question would be: so, is there any disciplinary jurisdiction now of this act? That if someone is found to be guilty
Oh, yes.
of elderly abuse,
Oh yes,
that-
the Act provides for that committee power, that receivership to be taken.
Okay.
Of course, on the application of another person, etc., or of that nature.
I love it. I love it. So I thank you for engaging with me on this very important discussion on the helm of World Mental Health Day. It really, really was beneficial and educational. I'm very happy to note that the law has provisions for protection of those in our society that are vulnerable, and I do hope that we were able to successfully communicate the importance of the application in general and its accessibility
Yes.
to members of the public.
You have summed up everything beautifully. It's been a pleasure.
Yes.
And I look forward to sharing with you some more
Yes.
on legalese and how we can bring it down to the level of the ordinary person.
so that they can understand, and we shall continue to Let's Talk Legal.
That's correct.
Have
Let's
a great
talk
day,
legal.
Avian.
Thank
Bye-bye.
you so much. The very same to you.
Let's Talk Legal is brought to you by Elle Daniel Associates Limited Liability Company, a legal administrative consultancy located number 1 Taylor Street and corner Arapita Avenue, Woodbrook. We can be reached at freelancelegaltt@gmail.com or call us at 241-3772, 241-3772, or email us at freelancelegaltt@gmail.com. Elle Daniel Associates Limited, democratizing law.